Yes, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay?
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, cause damage to the apartment complex after a breakup with a significant other. The complaining witness stated that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property, I believe that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. Defendant pushed his way through complaining witness and a witness.
Hold up, this guy pushed past witnesses and ran from a deputy over $45 in flower pots? Texas Penal Code Section 38.04 makes evading arrest a felony, but the judge just dismissed the interference charge. Smart call or too lenient? Sound off below.
A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. The defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment.
That's correct, Your Honor.
His apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, so typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
Okay, what all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leasees, the people that lease the actual
Because
premises.
if it belongs to the other person, then it's a criminal mischief. You can't break someone else's property.
But he's not the complainant. The complainant is the leasing manager for the apartment complex. They're alleging that the property belongs to the apartment complex.
Your Honor, from the DEMS, it says that each 3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to...
So it's like, it must be, cans that officers put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with.
I don't see how that was an interference.
Because what would they possibly put him in custody for?
So, Your Honor, just to clarify, what the DIMS say, and they go to the great lengths to explain this, is that there was a deputy there who was serving some sort of civil paper.
Sure.
And that he had to stop serving the civil papers to go to
chase
detain the defendant, because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the civil papers.
Correct.
It's not really clear from the information, is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers.
I think I agree with you on the interference,
Yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, or I'm going to order you, is not to go back to this place, not to have contact with the complaining witness.
I
Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail. You
understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
Okay. So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it. And then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. My be excused?
Yes, sir.
Thank you.
Martha, do you have an arrangement?
No, there's still an arraignment. All right.
Yeah, I don't think that there's much, but
All right, Judge, date 10, Gonzalez, come on up.
My left thumb.
all right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness say the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank a beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that said the defendant will slap CW and show up at, slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man. Or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
The judge just torched this case, ruling a "I'll slap you" text isn't a real terroristic threat under Texas law. Here's why. Threats require imminent serious bodily injury. But here's the question. Should verbal abuse between family members ever be criminalized?
Is it said exactly again?
Judge, the message that the defendant sent to complaining witness states, exactly, bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm going to find no probable cause. Ma'am, as the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you, you could end up in hot water. I'm going to find no probable cause in this case. The idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble,
Right.
I mean, you now know. All right, man, please. Just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait. Otherwise, you're free to go. Okay.
All right, Judge, next is page 12. Guzman, come on up.
You are here, Guzman? Sorry. Mr. Guzman, you're charged with two cases. You're charged with assault of a family member. You're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 29, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the DEM summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need
Whoa. Whoa, so that was an open case.
Listen, Judge? That one was a open warrant for a few months. A non-arrest.
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025,
This assault case started over a sandwich. The defendant allegedly bit his ex while she held their child. Now that's a Class A misdemeanor under Texas family violence laws. But here's what's wild. She never reported prior assaults. Why do victims wait until it escalates?
in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise.
The judge just nuked this guy's driving privileges. No exceptions, not even for 50 kittens in a burning building. Under Texas law, bond conditions can restrict driving, but is this too extreme for a first-time DWI with a 0.11 BAC?
The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you as a, can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, every single time that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you. A violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, ma'am.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda.
Are we just?
Yeah.
Judge, I actually have two cases, but they're both off docket.
Okay.
One of them is, I'll give the cause number, it's 252-5198. This one, we were here on Monday, okay? He needed to get the interlock, but he was out of town. My associate was here. You said you bond forfeited him. You said as long as he gets the interlock.
remember. Yeah,
Yes.
remember.
And then he's already filed a supervision order, and so if you could just reinstate him.
Did you get the interlock?
Yes, and he's already filed a supervision order.
Ready to go?
This is on.
I filed it, Your Honor. We signed the contract, and I did file this.
Okay.
Yeah.
As long as it's good and you're filing.
It's filed it. I've already filed it. We'll probably take a state part of you, and then we should.
Okay, I'll let her know that you reinstated it.
I did yesterday, so we should get this all through the.
Hopefully I did. I'll talk to her in a second.
Yeah, okay.
And my other one, Judge, is a walkthrough.
Gonna bring him up?
He's my walkthrough guy. Yeah, he's out in the hallway. Let me grab him real quick.
Do you need a translator?
Yeah.
Yeah, please.
Do I have to call them and let them know?
She can't, and she cannot. What's your question?
For the protection order, it's still in effect for 60
It's still in
Right.
effect, correct?
Do I have
Yes.
to let them know about this?
Who?
They're gonna be able to know.
Oh,
Your cases. Okay.
Yeah.
Thank you.
May we approach on?
Yes.
Okay.
Plot twist. The suspect worked at the Chick-fil-A where he hit the victim's car. Texas requires drivers to stop and exchange info, but this guy claims he felt an impact and just left with $5,000 in damage to an Audi. Should this be a felony?
And what is your cousin on that?
256-1688.
You get it?
I have it. I talked to Marcus.
Vasquez, right?
Yes, sir.
Okay. You are Kevin Vasquez.
Yes, Judge.
Mr. Vasquez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Yes, sir. On April 14th, 2025, in Harris County, Texas, law enforcement officers assigned to a follow-up investigation for failure to stop and give information. The complainant advised law enforcement officers that the defendant pulled out of a parking spot and struck the complainant's vehicle in a Chick-fil-A parking lot. Complainant advised that the defendant left the scene without providing any information. Law enforcement officers went to the Chick-fil-A and found surveillance footage of the incident. Store manager stated that they recognized the defendant as one of their store employees who was on shift that day. Store manager provided the defendant's contact information. Law enforcement officers arrived at the defendant's residence and spoke to the defendant's mother, who confirmed the defendant had been driving a motor vehicle that day, but her husband was the registered owner. Defendant contacted law enforcement officers, provided his Texas ID and insurance information, and admitted driver of the motor vehicle on the date of the accident. Defendant stated he drove out of the parking lot and felt an impact, did not see anything on the ground, so he left and went home. Defendant stated he did not call the police or file a police report.
Okay. Can you run his license, please?
Yes, Your Honor. And one other thing, Your Honor, we did get a damage estimate back, just for the damage purposes.
How much? Right.
$5,000.
But
we've.
Yeah, we've talked about that, Judge, and we've watched the video and there's a lot of pictures of of the
And
damage.
it always depends on the car.
That's exactly correct.
Lambo.
That's why. It's an Audi, but it's a 2013 Audi.
The judge gave a PR bond for a hit and run, but with a brutal warning, this is your one chance. Smart discretion or privilege. Note, the defendant still has his job at Chick-fil-A. Would this outcome be different if he weren't employed?